Well, good morning, good afternoon, good evening, wherever you are in the world as you're watching this either live with us or as a recording. Thank you for joining us. My name is Dave Cohen. I'm a director here at Mina Partners, and very happy to be able to share with you a conversation today with my colleague and good friend, Andrew Clearwater, who's a partner at Dentons, on looking back at 2025 in privacy and AI governance and looking ahead to 2026 to try to make some predictions about what we think might be some of the top priorities. So I want to thank everybody for joining us. And let me toss it over to you, Andrew, to tell the folks a little bit about your current post and your background.
Yeah. Thanks for joining. So my background is, I'm a lawyer that started out in tech, went to work in server rooms and research computing groups. And then after going to law school, kind of went into the policy space, the think tank space, worked for the IPP, worked for the Berkman Center. And then I went in-house and I worked for some startups, including OneTrust, which is well known in the privacy space. And now with Dentons, advising companies, all across the US and the world on topics around privacy, cybersecurity, and AI governance.
Excellent. Thanks, Andrew. It's great to be here with you here today. Thanks for making some time for us. And just so all of you know, what are kind of from our perspectives and for context. So Andrew is dealing with the legal obligations aspect of privacy and AI governance. And over here at Mina Partners, we operationalize privacy programs. So we work closely with internal counsel and external counsel, and we help our clients actually make things work and make sure that what companies say that they're doing with regards to compliance obligations, they're actually able to make functional. So you get both of those perspectives coming from the two of us here in this conversation. So to start, I think I'll kick us off just kind of highlighting a few of what Andrew and I were chatting about as we were preparing for this conversation. Seem to be some of the major trends in 2025, and again doing that as a way to kind of predict what we think might be some of the most important compliance priorities for 2026. So what happened in 2025 as we come to the close of the year that we want to highlight? One thing has to do with U.S. state privacy laws. For a number of years now, every year, at least for the 4 or 5, maybe even more years, there have been new state privacy laws introduced. And a lot of those had a fair amount of copy and paste to them, but also had some unique provisions that created specific obligations. But interestingly, in 2025, we did have 5 state privacy laws that came into force. So those obligations were live. But there were not as many state privacy laws being discussed and introduced. There seemed to be, for the first time in a while, not a lot of new action in state legislatures. So we're going to kind of get into that in a moment. We can talk about that. Another kind of key trend that we identified in this past year, certainly through the work that we saw with our clients over here at Mina Partners, was a focus from the regulators, and that's both state AG's offices and authorities like the new Cal Privacy. I still have to get used to calling it Cal Privacy as opposed to CPPA, as well as the FTC, were a focus on operational privacy. So previously, and by previously I mean over the course of the last few years, some companies may have felt like they're doing basic due diligence by having a privacy notice and maybe throwing up a form to be able to accept consumer requests for deletion and access and do not sell, etc. And maybe it worked, maybe it didn't work, but and that was maybe going to kind of pass muster for a while as a minimum. That doesn't seem to be the case any longer. What we're seeing is regulators using more and more sophisticated tools out there on the market that allow regulators to actually check for instance, we're doing a lot of cookie compliance right now. The ICO has been very active, sending out letters to different companies saying, we did a dummy test and we tried to opt out, and we opted out of everything, and we're still seeing these cookies being placed. So something's not working, something's broken. We need some remediation here. So the actual say what you do and then the do what you say part has really been active. So let me kind of pause there, Andrew, and just kind of get your take on whether you agree or what else you see as kind of some of the major developments in this past year from a privacy and AI governance standpoint.
Yeah, I mean, I definitely agree that there's been a shift where, having the necessary things in your website used to be a great way to avoid attention. Now those things are being tested. But I guess I would say that the website is an area of focus like no other, at least in California. Yeah. I mean, even in instances where companies were approached and investigated, a lot of those investigations stopped at the website, even when you could imagine there's a whole host of activities that are going on that were worth looking at, and maybe they were all perfect. But I think there's an idea here that this front end that is facing consumers needs to work, and it needs to work really well. Obviously, that's a big role that you guys play, and I think it's also making people realize the need to test these things, the need to sort of challenge themselves to keep up to date. And it's not just making sure the banner works; it's the opt-outs in particular that are tripping people up. And when it comes to litigation, I agree. Like some of these same mechanisms are important for CIPA, for the Video Privacy Act. You kind of see a lot of companies trying to use consent mechanisms and others to address these things. One thing that I will pull out is that when I look at one of the most recent, I guess it's actually July, so not that recent now, recent enforcements, there was a discussion about what the reasonable consumer could agree to for a purpose. Yeah. And I think it's been a while since we thought about the reasonable consumer. And I think that the US in particular has sort of a story around it that's like, if you have a really great notice, then someone can choose, and that's it. That's reasonable. Yeah. And I think it's worth looking at this, because if you're in a business where you might be, closer to the edges of what's reasonable, you should look at these 5 factors, which include the relationship between the consumer and the business. Look at the data, the nature and the type. Yeah. Look at the source of the information. Also look at the notice, but then look at the degree of transparency. And there's more that you can do with that, but I think it's one to look back at. If you're proposing sort of new and challenging business ideas, don't assume that like the world's greatest notice is your way forward. There might be more to it.
Well, Andrew, I couldn't agree more. And on a very related note, you just made me realize that another big development in this past year was the focus on, I love the term, dark patterns. Yes. It's been around for quite a while. It was talked about years ago in the early California legislation, but now it's, enforcement authorities are we saw some actual violations, big violations of this. And for people that aren't aware of that term, dark patterns, and what that means, I've always loved design. I'm kind of a design guy, and it has to do with the fact that you're legally not allowed to significantly manipulate the consumer to one choice over another. So for instance, if you really want to prevent the consumer from opting out of, sale of their information, and so you make that opt-out button small and gray in the bottom right-hand corner, and you have a great big green button that says opt-in, to receiving marketing emails, that's graphically steering the consumer to what you want them to do. And if that is particularly egregious, you can actually receive that can be an enforcement violation, right?
Yeah,
even play out, and to see that actually, companies actually get fined for that was really significant.
Yeah, it's sort of like making sure you're aware of the privacy user journey, and a lot of people are familiar with it, but maybe it's not a big part of their program at the moment, and they're maybe not able to leverage the importance of it until this year, where they can point to where that went wrong. And it's nuanced. I mean, even if you had perfectly sized, and colored buttons of equal size and everything, if it's going to take more clicks to do the privacy protective path, even that can lead to scrutiny. So I agree, that's a good one to have flagged.
Yeah, and we are to kind of pivot that into the positive in terms of business development, because not all compliance is necessarily a negative or a friction on moving business forward. It's important to note that the technological tools available to companies for privacy and AI governance management are continue to become more and more sophisticated. So when you mentioned user journey, Andrew, the tools are now able to provide consumers with choices at more and more sophisticated places, and it's becoming a lot more nuanced. So to provide consumers and customers with opportunities to opt out where they want to, but also to opt in where they want to further the business and to more refine, for instance, the marketing funnel. Those technical tools are becoming more advanced, sophisticated, and are out there. So, but anyway, that may be a little bit of a divergence. Let's get back to thinking about 2026 and kind of where we're heading there. And I know I'm just going to throw a couple things out at you, Andrew, to comment on as you will. Just very recently, we saw a new executive order out of the current administration with regards to AI governance. It was a kind of a big deal. It had a number of kind of significant provisions in it. There's a lot of TBD in it. We're going to have to do a lot of waiting to see how this plays out in terms of the real world. But I do think that it will have an effect on the state of play in AI governance. So maybe can you talk to us a little bit about that and what some of the significant provisions are?
Yeah, this is not the end or the solution. It's a data point along the way. So it's something for us to read and understand. Within the US, we have probably 4 comprehensive laws, if you arguably include California's regulations, and maybe 40 to 50 really specific targeted laws across the states. I would say addressing the use of someone's voice or something like that. And so there's the beginning of a patchwork. It's maybe not the way that you'd see it in the privacy sense, but in terms of approaches, the US, as compared to the EU, the US is concerned about keeping its lead within the AI space, its impact on the economy, national security. And so there's an effort to sort of clear the way, or at least maintain the openness that we have at the moment, from sort of new governance obligations on these companies. And to some extent, it's a split between the things that would be obligations that you do before there might be a harm, and what you would do because there is a harm. That's always a debate. So this executive order kind of maps out the actions that are going to be taken to sort of slow the spread of AI laws and potentially roll back the ones that we do have. But I wouldn't overreact to it. This is not how lawmaking works. That's what Congress is for. So it's a series of actions that have been triggered. There is going to be an AI litigation task force, and that will be really a federal effort to put pressure on the states and the laws that they have that are considered to be kind of in scope for this order. There is going to be a review by the Commerce Department to evaluate these state laws, as they did in sort of previous iterations of this or drafts of this. There's a connection between broadband funding and the types of laws that your state has in this space. So that is something that can be leveraged. So broadband equity access and deployment is a funding area that can be kind of put at risk. And they're looking for a way to carry out some sort of aspect of preemption going forward, and say there's a federal framework. And so some of that will be done through looking at what the FCC and the FTC can do. Ultimately you need, congressional action in a law to be preempting things, but there's motion in this direction. And I would say the focus is almost a reaction to SB 53 in California, the transparency law. That is, to go back to my earlier framing, something that those companies have to do before there's a demonstrated harm. And so there's a focus now on what would a federal uniform approach to that look like, or what would it preempt, I suppose. So Yeah, it's definitely one to look at. I mean, if I was preparing for the year and thinking about what to do, I guess I would make sure you would know at least what state laws apply to you at the moment. So, as you learn about some of these being challenged or delayed, but also, moving to probably a framework, probably standards-based like NIST or ISO, that allows you to run a good risk management program and let some of this change sort of just happen in the background for you as you move forward with your program. Because ultimately, a lot of the risk comes from, your reputation, harm to your customers, and compliance is obviously an important aspect and one that I talk about a lot. But I don't think you want to sort of get sucked into the drama too much, because this is just, a push and pull. There will ultimately be laws in this space, whether they look the way they do today, or going forward. And there's been, areas like, protection of children that have always been agreed to be carve-outs, which will get special attention.
Yeah. Well, so I think to respond to that, Andrew, you and I are both in the enterprise risk minimization business, right? And so with this executive order, I think it's pretty fair to say, if there's an underlying theme, it is, we don't want to have introduced additional friction to businesses in the United States that would prevent us from keeping up in the AI technology arms race with the rest of the world. We don't want to put in place onerous regulations that will let U.S. businesses fall behind. And so it's got a kind of a theme or a flavor that seems to be a looser regulatory framework. So, but to your point, Andrew, this is an executive order. The fact as to whether it could actually preempt more stringent state laws that companies are obligated to be in compliance with. We've seen this before. When regulations are loosened and there's real harm potential to customers, clients, and reputation for businesses, inevitably what happens is companies feel like, oh, we don't have to necessarily comply. Let's kind of loosen up. Let's save some money on our compliance efforts. And then what happens? You have a disaster, major data breaches. This is how the whole privacy field developed, privacy compliance development, why all these privacy laws exist, is because we had to learn first by a damaging event, big damaging events that hurt lots of people, and then people rushed around to try to fix it. But so our advice always is, if you want to get ahead of the game and you want to be proactive, what's likely to happen is, if and when those AI harms exist, they will be covered extensively through the media. Brand reputation will happen, consumer harms will happen. And then what happens after that? There's an outcry for regulation, and it'll start happening. So if you want to be ahead of that inevitable curve, you might think about some of the very foundational first steps in terms of AI governance. And Andrew, you and I talked about this in preparing for the conversation. Some of those things are pretty straightforward. You mentioned one a moment ago. Understand what state laws you are in scope for you, that you fall under. So just know what your obligations are going to be. Do an internal inventory. Understand what AI technologies are being used within your organization. Sometimes that can be harder than it seems in terms of shadow IT. We all know what happens in big companies. But try to get your arms around an inventory of what tools are being used. Importantly, what are they being used for? What are the outputs, and then prioritize those outputs in terms of potential harm. If the outputs have low potential harm, if it's internal, training, PowerPoint development, there's probably not a lot of risk of harm there. If you're making big decisions about credit scores, or law enforcement agencies are using predictive AI, which is notoriously bad at predicting outcomes, those are higher risk outputs, and they should be cataloged and evaluated. And if you're doing your due diligence and documenting that, and the fact that you've had a thoughtful internal conversation about that, you're well on your way to at least the rudiments of an AI governance strategy. Would you agree, Andrew?
I would. And I think it's important to know what's high risk for your business. I mean, the majority of these laws tell you what is high risk, and that is because it has a high association with societal harm. But you might be pooling data from 3 different vendors, which doesn't show up as high risk of harm to the society at large, but it would be highly impactful to your business if you did it poorly, right, as part of this AI project. And so there's always a reason to sort of move forward with a risk management program, even while the compliance space is shifting.
Yeah. Circling back to touch on something you mentioned a moment ago that I don't want to skip over. Another big development this last year that will play out next year in 2026 is age verification statutes and age design codes and children's privacy. Andrew, I know you've been doing some of this work with your clients, and I'm also particularly interested in the new inclusion of biometric information as well. So if you could touch on that a little bit and talk to us a little bit about what these new requirements, what's been happening there, what these new requirements are, and how that may play out next year.
Yeah, so it's 4 states. We've got one law that's going into effect January 1st, though. I'll come back to that. It may be challenged in a way that makes it not happen on January 1st. But then we have some 2 laws in the middle of the year, and then by January 1st of 2027, we pick up California. And all of these laws are around App Store verification. And the obligation of a company that has an app is not to do the verifying. The verifying happens with the Apples and the Googles of the world, who will go through a process, likely pairing to a parent in terms of the accounts and verifying the age and moving it over to you. This is by itself not full of new obligations, right? You just learn the age of the people that are using your app. And I should be clear, it's not as if you'll learn everyone's age on January 1st, right? Even if Texas's law is passed, it will only happen in Texas, and it'll only happen for new users. So there is sort of a ramp up period. Over time, people will keep downloading, more states will be joining, etc. But the real implication here is that where it comes to sort of protecting children, the majority of the attention, I think, was on things that were designed and directed towards children. So if you were, working on something that had, loads of cartoons and animations and had, bright colors, and all of this was intended to entice children to use the product, then great. You sort of knew what applied to you, and you knew what you had to do, even if it was hard. I think the difference is there were many people who, were putting together apps to sell things, to, share news, that just figured, well, some child at some point might log in, but who am I to say? And they moved on, and this would change to a position of actual knowledge. And once you know something with this level of certainty that comes from a verification sent to you from the platform, there's a host of laws that are kind of among the state comprehensive laws that start to take effect and have some impact. You're going to start thinking about, am I doing any sale of this data? I need to be thinking about carving out children. What about targeted ads? What kind of profiling am I doing? What kind of precise geolocation information do I have? And you could break that down, if you still want to collect it, to between the ones that are prohibited, the ones that are okay with consent. There's going to be some differences between the states there. And I think another area that comes in is these age-appropriate design codes. And that's living in sort of a suspended state in some ways, because the way these design codes have been put together, they're being legally challenged, and so they're not having the impact that they might. Some have not been enforced because of those legal challenges, but the idea is similar to what you were talking about when you're talking about dark patterns. Like, what kind of design should you have in order for children to be safe when they move on to these platforms and have to make privacy protective choices? So I think keep an eye on these design codes, because there may be, sort of a moment where enough of these are in effect, or the litigation gets resolved in a way that allows them to continue with enforcement. We know that the FTC is interested in enforcing the laws that it already has the ability to enforce. And there were some 2025 changes even to the federal rule. And we know with these age verification statutes and the implications under the comprehensive state laws, that's actually a decent amount of work. And I think a lot of companies in the US will have an app, somewhere that is promoting or selling, and it'll be worth looking at.
Yeah. Well, Andrew, we can't talk about that and not discuss what just recently took place in Australia, which was the passage of a federal ban on certain, just a small handful of particular social media platforms that are now illegal for children under the age of, I believe it's 16, to use. So curious as to your thoughts about, first of all, the fact that was passed as a federal bill in Australia and it's going to affect millions of people. And also just how do you see that playing out in terms of, the ability for it to be enforced and how that's really going to work, and any other challenges with that? Thinking that it's kind of a shot across the bow, I think, internationally for as a response to the well-documented harms that have happened to children from some of the social media platforms.
Yeah, I mean, this is as much about the law as it is about the I guess the failure to prove that the platforms that were selected are doing what they need to do. And so I think sort of like the executive order, it's probably a move among many moves. Like, this is the sort of thing that might instigate change, and then the necessity of having this law in place should go away. It's definitely not going to maybe have the effect maybe that they're going for, but I think it might move the market in the direction that they want. And by that, I just mean is, like, children are flexible and smart, and they will move to platforms that are not prohibited and maybe be subject to the same harms, but it will still give the market sort of the jolt that they might be looking for to start, taking more seriously these rules. But as a design for a law, it's probably not the best one to select just a short list of companies. So I'm sure there'll be some future revisions.
There'd be some challenges there. Yeah, that makes sense. Well, we only have a couple minutes left. This would be a good time, if you're out there in the audience listening live, to submit a question through the comments function there, and we'll do our best to take a couple of those if they come in. And if not, and while we're waiting for that, Andrew, just to kind of look forward to 2026 from a legal compliance standard, I'm curious about your thoughts on maybe top 3 or 4 priorities from a legal compliance standpoint for companies looking to either stand up or enhance their privacy and AI governance programs. What do you think are some of the key fundamental things that they might be well advised to focus on in the coming year?
Yeah, I mean, it's super basic, but you should at least make sure you're doing the annual review of your privacy notice. It's not a suggestion, it's a requirement, depending on which states you're in. So do that, date it, update the website. Having talked about the banners for 2025, I mean, this is a good time to check in on that technology. Maybe reach out to others if you need the help, but the dark patterns, the opt-outs, the consent, all of that, super important. Even some of the learnings that came from California around contracts with vendors make me think that, at least for your critical and high priority processing, that you should go back and take a look. Have you defined the relationship? Do you know what the commitments are? Have you reviewed further data sharing and the implications? Test your portals, test your rights management. As we talked about, that focus on children, make note, is there an opportunity here to kind of pick that project up early in the year, because the platforms are going to start rolling this out state by state, and you want to be ready for it. From the AI side of things, I think we're going to see, more than just updates to policy. I think there's going to be a little more work on training teams, a little bit more work on looking at supply chain risk. And hopefully teams will be getting a little bit more sophisticated about those risk assessments, and not just putting them in high risk and low risk kind of buckets, but to really get a little more dimension to the types of risk and routing it to the right people.
Yeah, that all excellent ideas. And from my standpoint, from an operational programs perspective, for privacy and AI governance, one of the things that we've seen a real uptick in the work that we're doing for our clients is either an initial or ongoing privacy program assessments. This is some work that we do that's very cost effective, can happen in a relatively short amount of time, and really just as an objective third-party evaluation of how's your privacy program doing, both from a notice and policy perspective in terms of the documentation, and also from an operational perspective as to whether that matches, your operations actually match what you say you're doing, both externally and internally. And what comes out of that is a gap assessment and a roadmap and a prioritization of what you should tackle in terms of your top priorities. If you want to really plug the biggest, most important holes first, maybe get even some low-hanging fruit. So we're seeing a lot of that. So that would be my recommendation as a kind of a top priority, especially at the beginning of the year. And then if you establish some priorities, you can follow through in the rest of the year and be able to accomplish that work. So we're just a little bit over. Want to thank everybody for taking the time to join Andrew and myself for this conversation. I hope you have found it interesting, and I hope you have a couple good takeaways. If you'd like to get in contact with us, our contact information is scrolling along the bottom of the screen there, so you can get in touch with us there. Please feel free to reach out to me at Mina Partners or to Andrew at Dentons. And we'd be more than happy to answer any questions for you or provide you with further information. So with that, I'll take us to a program close, and I want to wish everybody a very happy holiday season. I wish the best to all of you, for your friends and families, and I hope you get some good time off work and get to just enjoy the season. So thanks, everybody, one last time for joining. Thanks, Andrew, very much for your time today, and goodbye.
Thanks.